If you watched the South Carolina GOP debate on January 16th of 2012, then you may remember this exchange between Mitt Romney and the moderator.
Governor Romney, as president, would you have signed the National Defense Act as written?
Yes, I would have.
This was an excellent question addressing a highly visible and controversial issue which speaks to the core of America's civil liberties. Governor Romney gave a clear and unambiguous answer. Now, for those of you who are not familiar with the NDAA, or National Defense Authorization Act of 2012, it was an act signed into law by President Obama on New Year's Eve of 2011. This act did more than just fund the United States military for the coming year. It included vague wording in Section 1021, which could be interpreted to formalize and legalize actions which the current and prior administrations have taken in the name of the war on terror. These include allowing U.S. military to act as a sort of police force on U.S. soil, as well as apprehending terror suspects, including U.S. citizens, and imprisoning them indefinitely without trial or legal recourse, throwing the concept of habeas corpus, a legal right predating the Magna Carta, into the waste bin of history. Mitt goes on to rationalize his decision in this matter.
And I do believe that it's appropriate to have in our nation the capacity to detain people who are threats to this country, who are members of al-Qaeda. Look, you have every right in this country to protest and to express your views on a wide range of issues, but you don't have a right to join a group that has challenged America and has threatened killing Americans, has killed Americans, and has declared war against America. That's treason. And in this country, we have a right to take those people and put them in jail.
Governor Romney identifies the key trigger which would allow the U.S. government to act against its own citizens: treason. But what exactly constitutes treason? Speaking out against the actions of your government is not treason, but rather an exercise of freedom of speech. As with all crimes, a legal definition is required in order to uphold the law and correctly identify and prosecute illegal acts. Treason carries a special status in this regard. It is the only crime which is defined and whose standards for conviction are set forth in the U.S. Constitution itself. Virtually every other crime is defined at the state level. Section 3 of Article 3 of the Constitution reads, "Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court." But why is this? What led the founders to give special attention to the crime of treason? The framers had an awareness of the numerous and dangerous extensions of the definition of treason under English law. A vague or elastic concept of treason would inevitably lead to oppression and removal of political opponents and dissenters, as history had shown. By defining and setting conviction standards in the Constitution itself, the founders created a protection against government abuse of this capital charge.
And I recognize that when you're in a setting when there are enemy combatants, and some of them on our own soil, that could possibly be abused. There are a lot of things I think this president does wrong, lots of them. But I don't think he's going to abuse this power, and I know that if I were president, I would not abuse this power. And I can also tell you that in my view, you have to choose people who you believe have sufficient character not to abuse the power of the presidency and to make sure that we do not violate our constitutional principles.
Governor Romney chooses not to place faith in our Constitution, but rather trusts in the presumed self-restraint of Obama and any future president who will definitely be as virtuous as he assures us he is. On the issue of trusting our leaders not to abuse powers afforded to them by law, Thomas Jefferson had this to say: "In questions of power, then, let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution."
But let me tell you, people who join al-Qaeda are not entitled to the rights of due process under our normal legal code. They are entitled instead to be treated as enemy combatants.
Romney ends his argument by invoking the idea that there is a separate standard of law and civil liberties that applies to citizens and non-citizens alike when they are suspected of being enemy combatants. How does he arrive at this conclusion? The NDAA legitimizes the concept that the whole world is a battlefield, allowing individuals to be declared enemy combatants no matter where they are discovered or what they are doing at the time of capture. This idea leaves no room for the concept of innocent until proven guilty, which is at the core of the rule of law. Indeed, Romney defends a scenario wherein the government, by classifying you as an enemy combatant prior to capture, specifically denies you the opportunity to prove that you're innocent or review any of the evidence against you. This is a clear violation of the right to due process that is guaranteed by the Fifth Amendment. And yet, Romney has no problem with this because he either presupposes that you are guilty of treason or believes that because you're suspected of being an enemy combatant, that the Constitution no longer applies to you. But there is no clause in the Constitution, the supreme law of the land against which the legality of any other law is measured. There is no clause in this document which provides a different set of right in times of war or to enemy combatants. The Bill of Rights does not even refer to citizens, but rather constrains the government from infringing on persons who by pre-constitutional natural law possess rights by nature of their humanity, whether they be criminals, terrorists, or not. The founders themselves had been labeled terrorists, yet they knew and loved liberty and justice, and they feared the tyranny of unrestrained government. The remarkable feature of the American system of government, which was unique to the world at its inception, is that rights are not conferred by the government upon the citizenry, but rather the government is specifically constrained from imposing upon rights which pre-exist and supersede man-made law. While this philosophy has been covered up by the passage of time and generations, it's still ingrained in the text of our founding documents. Compare the words of the Constitution with the self-serving rationalization of those that would aspire to power.
In terms of the commander-in-chief's ability to set aside rules, in wartime, presidents have very wide authority to do what it takes for the country to survive.
The limitations on government power included in our Constitution are not inconveniences which must be rationalized away to face the modern world. They are essential guards against the unabated excesses of government which inevitably work against the people. By understanding the value of our Constitution and selecting leaders who share the same reverence for the wisdom of its tenets, we can restore America's position as a beacon of freedom and liberty in the world.